somebody could rely on the state following that opinion as notice of how it is or is not going to enforce the rule? I mean, we talked about that hypothetical person who was wondering what he could do to conform his conduct to the rule and whether he was going to get in trouble or not. I mean, part of what he might say or she might say to herself is, geez, that was just preliminary. I don't really know what it is. What about that?
If I may, I'll respond on behalf of the state. The nature of a preliminary injunction hearing when it pertains to First Amendment rights is for the court to search out and see if there is any reasonable likelihood that the plaintiff can be correct that the statute or the rule in question is unconstitutional. So, in essence, what Judge Connolly's injunction concluded was he had questions about whether or not it was constitutional to apply to groups of less than 20. However, for groups of more than 20, the judge had no question about whether or not that would be constitutional.
Excuse me, Your Honor, that's just false. That's flatly false. That's
Okay, Mr. Turner, we're going to let, okay, well, we're going to let him finish, but I would make the observation, though, I'm not sure you're of record in the case. We've already had some discussion here about following the rules and so forth, and typically we would allow only an attorney of record to speak, and as a matter of fairness, typically just one person per side. So, before when you spoke, it was to supply some factual information that I wondered about what more could be added beyond what was before Judge Connolly, but it seems to me we should really have the one lawyer per side rule here. I would enforce that on the defense as well. But complete your thought. Go ahead.
Certainly, Your Honor. So the point being is that Judge Connolly did not find any reason to question the constitutionality rule if it was applied to groups of 20 or larger. So that's why it is both a preliminary decision, which is non-final, but at the same time, it has some validity in giving this department and the state some guidance as to how it should be applying the rule. Thank you.
Okay, thank you, sir.
Well,
hold on.
Sorry, yes, Your Honor, sorry.
So, but Ms. Weezy, you were the one that used the term before preliminary, and your colleague just said, well, this gives us, can maybe give some person some guidance going forward and so forth, but is that enough where we're talking about the right to free speech? We've talked about the chilling effect. We got to know what is permitted and what's not. Is it enough to say this preliminary opinion is going to give us some guidance? It seems to me it still doesn't tell somebody what they need to know.
As I noted earlier, I think that those issues were addressed in the written submissions that were provided by the state court, and agree with the characterization that there were some guidelines and that the state followed those guidelines. However, the decision was not a final determination, and that is the position of the state.
Thank you, Ms. Weezy. Mr. Turner, anything else?
Well, Your Honor, it's not a final determination. The reason it's not a final determination is because the state chose to settle. So the state essentially conceded the point. I mean, I think we need to have some serious inquiry into why it was the state chose to settle. I mean, they foreclosed any further court proceedings on this case because they chose to settle the matter out of court.
Thank you, sir. I had one other question for you in reading the brief. You make the additional point beyond what has been argued by others about First Amendment issues, and that is that the state engaged in what you call the highly selective enforcement process. Is there any evidentiary record, though, that I could rely on to make a determination about that? I mean, I don't, all I have is a citation. I mean, I don't even know, for example, what specific conduct it is that your client was engaged in and would not get to that point until the trial. So how can I make a determination that there was a selective enforcement process when I know your client was charged, I know these other people were charged, but I don't know who else might have been charged. I don't know whether, hold on.
Yes, I'm sorry.
I don't know whether there were other people doing the same thing as your client who weren't charged. I suspect that's the case. But how do you expect that I should be able to determine that this was a highly selective enforcement process without that kind of record?
Well, Your Honor, there are two sort of different levels of selectiveness here. There is the universe of people who are participating at that time, at the same time as my client, and whether she was selected out among those people. But there's also the question of why it is that this particular group of people was subject to this enforcement action. And what I'm saying is that they were selected, that the state is choosing selectively to enforce their 20-person rule against this group of people when they don't enforce it against other groups of people.
How do I know that?
Well, I'm sorry, Your Honor, I would be more than happy to present some evidence that, you know, other people, you know, groups of more than 20 people routinely enter the state capitol as groups and they don't get cited. I mean, you know, can I give you a specific example right off the top of my head? Probably school children, for example, you know, on a regular basis. And so if you really want me to go find out a specific example of another group of 20 people who entered the Capitol during this time that did not receive any citations despite being more than 20 people, we can probably do that. I'd be happy to try.
Okay, well, unless there's anything else, I have read your materials, I appreciate the argument, and